A case must be justiciable to be heard in federal court, which means there must be a case or controversy presented. To determine whether a case or controversy exists, the case must satisfy requirements for standing, ripeness, mootness, or political question doctrine. A party must have a concrete interest in the outcome of a claim to have a claim be heard in federal court. This is called standing. The requirements for standing are: 1, that the injury, which is when the plaintiff must have suffered some injury or show a likelihood of imminent injury. 2, causation and redressability. Plaintiff must allege that defendant caused the injury, that the court can grant a proper remedy. No generalized grievances. Plaintiff can't sue solely as a U.S. citizen or taxpayer to compel the government to act in a particular way. The one exception is that taxpayers do have a standing in challenging specific government expenditures pursuant to the Establishment Clause. Congress cannot automatically confer standing, but can create new rights that, if violated, may give rise to standing. Third-party standing is when a plaintiff with standing may assert the rights of a third party where plaintiff has suffered injury and either A, plaintiff's injury adversely affects his relationship with the third party. This happens like a doctor could assert a patient's right in challenging an abortion restriction. Bar owners could assert underage male rights in challenging ban or beer sales to underage males. Or B, injured party is unlikely or unable to assert its own rights. This could happen when there's association could challenge the law requiring disclosure of member identities because members could not challenge the law directly without revealing their identities. Organizational standing. Organizations always have standing if the injury is to the organization itself. Suits on behalf of members. Organizations may sue on members' behalf if 1, the injury to the members that would give members standing to sue individually, 2, injury is related to the organization's purpose, and 3, neither claim nor relief requires participation of individual members. Then there's ripeness and mootness. To be justiciable in federal court, a case must contain a ripe claim and live in a live controversy. It cannot be moot. So the ripeness, the dispute needs to be matured sufficiently to warrant a decision. Plaintiff is not entitled to review a law or government act before it has been effectuated. Mootness, a live controversy must exist at all stages of review. If circumstances causing plaintiff's harm cease to exist after a plaintiff files suit, the case must be dismissed as moot. The exceptions are 1, wrongs capable of repetition but evading review. So this arises where the injury ceases before complete litigation of the claim, but plaintiff can reasonably expect to be subject to the same harm in the future. So an example might be a disabled bar examinee seeks an injunction because denied accommodations and can't take the exam because it occurred before his case is heard. It's not moot because he will need to take the bar exam again. Another exception is voluntary cessation by the defendant. Defendant has ceased the act of giving rise to the plaintiff's suit but can resume them at any time. And the third exception is class action lawsuits. Only one member of the class must have an ongoing injury. Then we have the political question doctrine. Federal courts will not adjudicate certain constitutional issues that constitute political questions. Political questions involve issues that the Constitution commits to another branch of government, that's like not the judiciary, or are inherently incapable of judicial resolution or enforcement. Common political questions deemed non-justiciable are actions under the Republic form of government clause, challenges to conduct of foreign policy, and challenges to impeachment and removal proceedings. Non-political questions deemed justiciable: production of presidential papers and communications. Original jurisdiction. Under the Supreme Court, Article 3, the Supreme Court has original jurisdiction over suits between states in cases involving foreign ambassadors and other foreign ministers, such as, such cases must be filed in federal court. An exception are suits brought between states must be filed in the Supreme Court of Congress and cannot expand court's jurisdiction to other types of cases. Methods of Supreme Court review. Discretionary review. Most cases get to the Supreme Court by writ of certiorari. The court then decides whether to grant review. Mandatory review. The court must take appeal from 3-judge district court panels regarding injunctive relief. This bypasses the Court of Appeals. Final judgment requirement. Supreme Court only hears cases on review if there has been a final judgment of a lower federal court or a state's highest court. Congress may limit courts' appellate jurisdiction to certain cases under Article 3. State court decisions. Supreme Court cannot review a state court's decision that rested on an independent, adequate state law grounds. For example, if the state's decision is based on federal and state law, the Supreme Court will not grant review unless the decision cannot stand on the state grounds alone. The 11th Amendment and the related doctrine of sovereign immunity bars suit against state governments in federal court. Under the 11th Amendment, federal courts cannot hear claims from a private party or foreign government against a state government. Sovereign immunity bars suits against states in state court. Exceptions are suits against state governments are allowed in federal courts where A, the state waives sovereign immunity or consents, B, the suit involves the enforcement of laws under Section 5 of the 14th Amendment and Congress has removed immunity. C, the federal government brings the suit, or D, bankruptcy proceedings. Suits against state officers can be brought in federal court if the suit involves either A, injunctive relief claims for violation of the Constitution or federal law, or B, claim for money damages to be paid by the state officer personally.